Turn to M3 and Karen B for this week's episode of Comply on the Fly. You'll get quick and timely answers to the most common compliance questions so you and your business can keep moving ahead. Please note this podcast and the contents herein do not constitute legal advice. Please seek the advice of counsel for any benefit compliance related implementation guidance or strategy.
Hello everyone, I'm Karen B, and the Comply on the Fly question of the week is, how does HIPAA apply to my group health plans? Great question. Sometimes the topic of HIPAA can be confusing to employers. The biggest reason is that many employers believe that any medical information that comes into the organization is protected by HIPAA, and that is not true. Keep in mind that HIPAA obligations apply to what we call covered entities. Covered entities under HIPAA are healthcare clearinghouses. Those are places that process non-standard health information to conform with certain standards for data content or format on behalf of other organizations, providers, doctors, clinics, hospitals, and then, of course, health plans. This would include insurance companies, employer-sponsored health plans, and government programs like Medicare, Medicaid, military insurance, and veterans programs. Although some of you may fall under the definition of a covered entity because you are providers, our focus here is on the health plan as a covered entity. If you sponsor a group health plan, such as medical, dental, vision, medical, FSA, or an HRA, health reimbursement arrangement, the plan or plans themselves are the covered entities, not you as an employer, which is a little strange, but important to remember. In your role as employer, you may see or maintain or document medical information for employer functions, such as FMLA, work comp, or disability claims. But those records are not protected in this context by HIPAA. They absolutely should be protected and kept confidential, but your involvement with those records does not invoke HIPAA. Rather, the plans you sponsor are subject to HIPAA, and your compliance obligations will largely depend on whether those plans are fully insured or self-funded. If you sponsor fully insured plans, typically the HIPAA obligations rest with the insurance company, unless, of course, you are receiving protected health information from the insurance company, which is generally not the case. Most often, insurance companies will not provide you with PHI or protected health information, and therefore you are considered hands-off PHI. Most HIPAA obligations in that situation will rest with the carrier or carriers. However, if you are self-funded for medical, dental, vision, or sponsor a medical FSA, flexible spending arrangement, or HRA, which are technically self-funded plans, then you will have all of the HIPAA obligations, including having HIPAA privacy and security policies, providing the notice of privacy practices to plan participants, having business associate agreements or BAAs with your third-party administrators and vendors and even your brokers, conducting a risk analysis, and providing training to employees who may encounter PHI in relation to these plans, just to name a few. Having the required documentation, including policies and procedures, is key to your HIPAA compliance when you sponsor these types of plans. And that is your Comply on the Fly question of the week. Thanks for tuning in.
What's on your mind? If you have a pressing compliance question, send it to askkarenb@m3ins.com. We'll do our best to cover it in an upcoming episode. You can now follow and subscribe to Comply on the Fly on Spotify, iTunes, and Google Podcasts. Make sure to tune in next week and encourage others to join us.